Mr. Hanson.
I'm grateful, my Lord. My Lord asked me a question just before the short adjournment about the application of the Chikwamba, inverted commas, principle post-Hyatt. I'm not sure I can give the court an exhaustive and comprehensive answer to the question posed. I mean, in the time I've had available, for example, a search on Lexis using the keywords Chikwamba and Hyatt reveal 22 decisions of the upper tribunal and above since Hyatt in which Chikwamba and Hyatt have been considered together. And surprisingly, of those 22, only 3 are in the Court of Appeal. One is Kawa, that I'm going to come on to in due course in any event. One is a permission decision called Jabate, and the other is a case called Tika, which is a substantive decision, but a strange one, where there was a concession that there had been an error of law, and the argument was really about the materiality of that error. And I'm not sure it really lends much to the analysis. But can I additionally attempt to answer it in this way by just looking at how that interrelationship, if it can be described as such, has been discussed in subsequent cases post-Hyatt. Can I come to Kawa last? Can I just draw the court's attention to 3 upper tribunal decisions that I accept they're only upper tribunal decisions, but they are dealing with this issue at the coalface on a regular basis, and so they're a helpful indication in my submission as to the approach consistently taken. And can I start that analysis by reference to Eunice? I may need to come back to it, but just for this purpose, at page 362, the presidential panel in Eunice discuss the Chikwamba principle in some detail, and the discussion, the court may want to see where the discussion begins. It actually begins at 360 under a bold heading that says Chikwamba principle. So it begins at paragraph 78. But for present purposes, if I could just refer the court to paragraph 87. There they refer to Chikwamba as interpreted by the Court of Appeal in Hyatt.
Yes.
They refer additionally at paragraph 88 to the Kawa case that I was going to take the court to in any event. And then they also refer at paragraph 89 to the upper tribunal case of Chen, which I was also going to take the court to in any event. And I referred the court earlier to the case of Thackrell at page 317, which was another instance of that tribunal with Mr. Justice Nichol in presiding, applying Chikwamba as interpreted by Hyatt. But can I just, before I'm going to refer briefly, if I may, to Agyarko, then Kawa, then turn to the statute. But before I do, can I just analyse the principle, if indeed it is a principle, in this way? Because I think it's helpful to frame the discussion. If these appellants, either one of them or any appellant in any given case, is certain to be granted entry clearance, and I submit following Agyarko, nothing less will do than certainty. if that applicant leaves and applies from abroad for entry clearance, the question of any prolonged separation won't arise. They will be granted entry clearance and they will return, and any separation will be temporary. And in those circumstances, it's hard to see how there can be any breach of Article 8 rights. If any particular appellant is not so entitled, in my submission, it would be wrong for him or her to circumvent the rules by having married when he or she had no leave to be here in the first place. So I respectfully come back to my Lord Justice Peter Jackson's point that this is a factor, one amongst many, in a multifactorial proportionality assessment. In my submission, it needs to be viewed and applied in that context. And as I say, that the consideration of those factors alongside the primary submission I make about its scope or application, namely that it only really engaged at all where the decision maker refuses an application on a narrow procedural basis requiring the person to apply from abroad. And as I already submitted, neither of these cases involve such decision making. My lords, my lady, Agiarco, you've been taken to. I'm not going to go back over old ground, but I do highlight three particular features. I've emphasised the importance in the eyes of the Supreme Court of the precariousness jurisprudence that was already part and parcel of our jurisprudence, I submit, but has gained force and weight and a new impetus following the Grand Chamber's decision in Jeunesse. And that's a point that Lord Reid dwells on at some length at paragraphs 49 to 51. And he concludes at paragraph 50, just below the letter H, this is at page 54, the fact that family life has been established by an applicant in the full knowledge that his stay in the UK was unlawful or precarious affects the weight to be attached to it in the balancing exercise. Secondly, Para 51, where Lord Reid deals with Chikwamba, it won't, I think, surprise the court to hear that I emphasise two words in particular in the penultimate sentence in paragraph 51, the words certain and might. Nothing less than certainty will do. And even where it is certain, it's not a trump card. There may be other factors in the immigration history of the particular applicant which militate clearly in favour of removal, even temporary removal, for the purposes of an entry clearance application. And finally, dealing with Agiarco, it's really echoing a point that my Lady Justice Laing made. And it appears clearly from paragraph 57 at page 56, where Lord Reid emphasises, it's really from the letter F down, emphasises the importance of giving appropriate weight to the Secretary of State's policy as expressed in the rules. And in particular the public interest in removal. And again, the last sentence in paragraph 57 is a sentence I rely on. These are both precarious family life cases, and I submit neither reveals a very strong or compelling claim. On the contrary. Can I then finally ask, on this point, ask the court to look at Cower at page 177, the authority begins, and I should draw the court's attention in particular to the discussion beginning at page 190, para 41. The court there sets out Chikwamba. The court records the terms of the policy instruction that I drew the court's attention to earlier, and then the statement of principle by Lord Brown at para 44 of the Chikwamba case. And then at 43, Lord Justice Holroyd says it must be noted the facts in Chikwamba were striking. And then he sets them out, and I set out substantially the same facts in explaining the decision in that case. He then refers to Hyatt in the upper tribunal. And then at para 45, and I should say Hyatt in the Court of Appeal dismissed the appeals from the upper tribunal. And then at para 45, he refers to Lord Reed's judgment in Agyarko at paragraph 51, at which we've just looked. And he emphasises the features that I've emphasised. Relevant to note there, he there spoke of an applicant who was certain to be granted leave. And in such case, there might, emphasis added, be no public interest in removing. In my view, is a clear indication that the Chikwamba principle will require fact-specific assessment in each case, will only apply in a very clear case, and even then will not necessarily result in a grant of leave to remain. So, my lords, my lady, before I turn to the statutes, the essential submission is that, in fact, neither of these applicants can successfully invoke the Chikwamba principle. And in my respectful submission, their positions are not made stronger by sections 177A and B. On the contrary, in fact. Can I ask you then to turn up again the sections at page 2 of the authorities bundle? My learned friend's taken you to them. I can deal with the text very quickly. Section 117A, subsection 2, requires any court seized with the public interest question, as it's defined in subsection 3, to have regard to the considerations listed in section 117B. Section 117B then begins with a number of statements as to the public interest, effective immigration control, the ability to speak English, financial independence are all there identified as being in the public interest. Subsections 4 and 5 then identify in what circumstances little weight should be given to a private life or relationship formed whilst that person is in the UK unlawfully or their status is precarious. Subsection 6 then creates a specific and limited exception to what the public interest would otherwise demand, where the conditions in subparagraphs little a and little b are met. And it's been described as a benevolent provision in subsequent case law interpreting that provision. But the point for present purposes is a simple one, but an important one in my submission. There's nothing comparable to subsection 6 to cater for Chikwamba type cases. It would have been relatively easy to say something like, in the case of a person who's not liable to deportation, the public interest does not require that person's removal where it is certain that they would be granted entry clearance if they applied from abroad, or words to that effect. But there's nothing to that effect, and that's essentially what the presidential panel in Eunice decided, and they were clearly right so to decide. So my lords, my lady, it's no part of my case that the Chikwamba principle has not survived the amendments to the 2002 Act. But the submission is that the Chikwamba principle has certainly not been fortified by those provisions. On the contrary, in fact. And Malernid's invocation of the concept of flexibility, which he says is an important feature of the statutory scheme, in my submission doesn't really get him to his destination. As my Lady Justice Laing observed, in a sense, the whole flexibility is inherent in the process as a whole of dealing with an Article 8 claim on the grounds of family life. And the concept of little weight is itself intrinsically flexible. There are grades of little weight. I accept what my lady said about that. And that's all that Lord Justice Sales was saying when he said you could accept that there was a limited degree of flexibility without doing violence to the statutory language. So I accept all that, as I must, as it's vouched for by Rapier in the Court of Appeal and subsequently in the Supreme Court. But in my submission, it doesn't avail the appellants in this case, where there are such strong countervailing factors that clearly tip the balance the other way. Dealing with the statutory considerations, I say this. Firstly, as a matter of construction, there's nothing in the terms of sections 117A or 117B that expressly assists either appellant or makes their otherwise weak Article 8 case any stronger. There is, as I said earlier, no benevolent provision akin to 117B6 in play here. On the contrary, I submit the provisions of section 117B generally weaken the appellant's case or are at best neutral. Financial independence, for example, as explained in Rapier, is at best a neutral factor. Likewise, the ability to speak English, where the appellant can. Secondly, and importantly in my respectful submission, there is nothing whatever in the statute that diminishes the strength of the public interest in effective immigration control, even in cases where the likelihood is that the appellant would succeed if he applied for leave from abroad. And in my respectful submission, the presidential panel in Eunice were right when they said there's no exception in Part 5A for an appellant who argues they'll succeed with an entry clearance application. Can I invite the court to turn up, Eunice? It begins at page 346. Can I invite the court's attention? Apologies, we're going back to it. But just to frame the discussion, if one starts at page 360, one sees that bold heading that identifies the context that they are here discussing, the Chikwamba principle. And although we have only sidelined, or I have only sidelined, para 90, the court should really begin reading from para 78. But for present purposes, I rely in particular, firstly, on paragraph 90 and what is there said about the interrelationship between Part 5A and Chikwamba. And I rely in particular on the sentence 9 lines down that says there is no exception in Part 5A of the 2002 Act or elsewhere for cases in which an appellant following removal will succeed in an application for entry clearance. And then there's a reference to the Act, and then the last sentence says reliance on Chikwamba does not obviate the need to do this. And then I do commend, if one turns on, the court may wish to read the whole of the passage that follows from 92 onwards, but I commend in particular the structured consideration that one sees at paragraphs 102 to 106, beginning at page 365. And I'm going to come back and deal with the individual appellants in a little more detail shortly, but just working through that structured approach. Section 117B1 provides the maintenance of effective immigration control is in the public interest. Given both appellants' very poor immigration history, including prolonged overstaying in breach of the conditions upon which they were permitted entry, in my submission, this factor weighs heavily against both appellants. Secondly, it is in the public interest that persons who seek leave to remain can speak English. This may seem a small point, but it's not. Mr. Rahman cannot speak English. And that's one of the reasons why, far from being certain to succeed with an entry clearance application from abroad, he would be certain to fail with an entry clearance application from abroad. And the upper tribunal so held and were right to decide that. And I'll come back to that. Well, I'll touch on that point when I come back to their decision. Then financial independence, section 117B3, is a neutral factor. Section 117.4b is clearly relevant and weighs heavily against both appellants because they formed their relationships when they were here unlawfully. Section 117b5 is concerned with private life. We are primarily concerned here with family life, but insofar as private life factors arise or are relied on, they should be given little weight. And section 117b6 does not apply. So, my lords and my lady, my concluding general submission on the common issue as applied to these two appeals are these. One, the Chikwamba principle is not in fact engaged in either case. Two, neither application, and this is really follows, this is part and parcel of one, neither application was decided on the narrow procedural ground that the applicant should return home to apply for entry clearance from abroad. Three, both applications were decided on their merits following appropriate proportionality assessments by the relevant decision makers. Four, neither application would be certain to succeed on an entry clearance application made from abroad, and even if the court were satisfied that in Mr. Allam's case it was certain that he would succeed, I reiterate the point I made when I began my submissions after the short luncheon adjournment. If he's entitled to entry clearance, then the question of any prolonged separation simply won't arise. Five, insofar as Mr. Allam's case, application for entry clearance might, or even if it's certain to succeed on the evidence as it stood, that is insufficient in my submission. And his immigration history is such that it was clearly proportionate to refuse a further leave and leave him to apply from abroad for entry clearance if so advised. Sixthly, neither application in my submission gains any traction whatsoever by reference to Part 5A of the 2002 Act. Seventhly, on the contrary, the need to have regard to the public interest considerations therein set out significantly weakens what were already in my submission weak Article 8 claims. Contrary to my learned friend's concluding submissions, in my respectful submission, both these cases are in fact paradigm instances of circumstances where it is proportionate to insist upon the appellants applying for entry clearance from abroad, given their immigration history, given the absence of any children, given the fact that they embarked upon their family life, knowing that they had no right to remain in the UK. And in those circumstances, requiring them to make a valid entry clearance application is not, in my submission, disruptive or Kafkaesque, as Lord Scott feared in Chikwamba. It is a proportionate response that serves the important public interest in effective immigration control. Having said all that, I do accept that the public interest in effective immigration control is not a trump card. There are no trump cards in this field. The statute requires the court to have regard to the public interest considerations in section 117B. But I do submit that in the ordinary course, requiring an applicant or applicants with these immigration histories to leave the country and make an out-of-country application does not amount to mere unthinking insistence by the Secretary of State that the rules should be obeyed. It is, in my submission, part of a perfectly legitimate endeavour to ensure that the United Kingdom has a coherent and fair system of immigration control. returning then, if I may, to the individual appeals and adopting the balance sheet approach that is commended in so many of the authorities, including Heshem Ali that we looked at earlier. In my submission, it's instructive to actually look at and analyse the factors that might weigh in favour of each appellant. I've, understandably, focused on the adverse factors, but the positive factors in my submission are very limited indeed.
Could I just, Mr. Hanson, could I just ask you this? I mean, we're not obviously deciding these cases ourselves.
No.
I mean, our task is not to make a balance sheet, but to consider what the decision makers made of this. So yes. Are we going to be helped by a balance sheet approach ourselves?
Well, only this then. In my submission, the Tribunal did identify the limited positive factors in favour of each appellant.
Right, so what you're about to do in that case is to create a notional balance sheet by identifying what you say are the important features of each case, and then you'll take us to the decisions in order to show.
Yes.
Is that the process we're engaged in?
That's the process.
All right. So you can rattle off quite quickly in that case. What
yes. Well, I'm going to do it very quickly, yes. If I may. In Rahman, mm-hmm. and the references in the decision are paragraphs 83 and 86 at page 135. There were findings that the appellant and his wife were likely to face some disruption and hardship, albeit not very serious. In addition, there was a discussion of whether the sponsor would receive the same standard of healthcare in Bangladesh. One sees that at paragraph 86. In Mr. Allen's case, in agreement with the point Lady Justice Laing put to my learned friend, and contrary to his submission, I submit it's absolutely clear from the decision that the Tribunal did assume in his favour that he would be likely to succeed with an entry clearance application. And also considered that they would be likely to face some disruption in having to return to Bangladesh. But the point about Mr. Allen's case, and I'm going to make good this when I come to deal with ground 2 in particular, the point about that case, at first instance and in the upper tribunal, both tribunals emphasised the paucity of evidence on the appellant side of the court. That's a recurrent theme in both judgments, and the course of argument is important in considering the decision-making in that case. Can I then wrap up in this way? Mr. Rahman, in a sense, nothing more needs to be said. He has permission only to apply on the single ground relating to the interplay between Chikwamba and the statutory provisions. In my respectful submission, Chikwamba's not in play. He wasn't refused on the narrow procedural ground. His application was refused on its merits. There's a finding, a dispositive in my submission, finding by the upper tribunal that there are no insurmountable obstacles to family life continuing in Bangladesh temporarily, if both family members want to move there whilst he applies for entry clearance, or permanently. in any event, even if the Chikwamba principle were in play, he would not be certain to succeed on an entry clearance application. On the contrary, he would be certain not to succeed. Can I invite the court's attention to the decision in that case, in particular at page 117. One starts at paragraph 10, it's just to set the scene. This is the tribunal expressly considering whether he can satisfy the rules for leave to remain as a spouse. And it's accepted he meets the suitability requirements, paragraph 11, in terms of the relationship. But then it's accepted by the appellant that he cannot satisfy the eligibility requirements. At paragraph 13, reference is made there to the eligibility requirements. And over the page, nor is there evidence that the appellant can satisfy the English language requirement of paragraph ELTRP 4.1, which apply unless EX1 is met. So we know EX1 is not met because there's an unappealed finding that there are no insurmountable obstacles. And we know that he cannot satisfy the English language requirement. So Mr. Rahman would be bound to fail on his application for entry clearance. This was one of the points Lord Justice Newey pointed out in his permission grant, that Mr. Rahman's case was problematical for that reason. And I say there's nothing in section 117A or B that assists him, however the court approaches that issue of flexibility. And my learned friend was just one final point on Mr. Rahman's case. My learned friend is critical in his skeleton and in his oral argument of the passage at paragraph 85, page 185. Where Upper Tribunal Judge Smith said, well, it's hard to see how Chikwamba can apply here at all.
Page number again, please.
Page 135.
Thank you.
Given that there are no insurmountable obstacles. And in my respectful submission, there's nothing wrong with that. It's right. It echoes, going right back to Chikwamba, it echoes the fact that the court needs to consider the point about separation. If there are no insurmountable obstacles, then there are no obstacles to family life continuing abroad. But as Belton braces, the respondent has put in a respondent's notice. I submit I don't in fact need to rely on it. But if I do, on this point, I submit the outcome of the balancing exercise in this case was inevitable and any error was not material. Finally then, turning to Mr. Alam's case, obviously I repeat what I've said about Chikwamba, the fact that his case was decided on its merits. I've engaged briefly with the point about certainty or otherwise of his entry clearance application. Before lunch, Lord Justice Snowden asked me what my position was, and I hope I've tried to be clear. On the one hand, I accept, indeed it's part of my case, that the first-tier tribunal proceeded on the basis that, on the evidence as it then stood, he would be certain to succeed on an entry clearance application. And I don't resile from that fact. That's what the decision reveals. I was simply making the point to explain my skeleton that there is some suggestion, and I took the court to that reference in PZ, the point in time at which you consider the merits of the entry clearance application may shift to a later date. But in my submission, one doesn't perhaps need to engage with that nuance in this case. I'm content to address Mr. Allen's case front on the basis that he would be certain to succeed. And indeed, I say that's the premise upon which the case was decided, both in the FTT and the upper tribunal. And can I make good that point by inviting the court to look first at the decision of the immigration judge at page 159. It's the passages we looked at before from 31, 32 and 33. In my submission, they're only sensibly capable of one construction, namely that the tribunal was proceeding on the basis that Mr. Allen could satisfy the rules, and I submit it's blindingly obvious, in fact, and I echo the point that Lady Justice Laing put to my learned friend, that what the tribunal they're doing are saying yes, but, and that's the point in the concluding sentences of paragraph 33 over the page at page 160. And I say I'm fortified in that submission by Upper Tribunal Judge Smith's decision, because she proceeds on the same basis and records the fact that had previously been accepted. And one sees that page 113.
Do you mind, before we go away from the FTT?
Yes.
Because we had just been taken to 31 to 33. What are we to make of the second half of paragraph 32? You say that one can read from that she accepted that he was certain to succeed. Do you?
Yes. Well, I say you've got to read 32 and 33 together.
Yes, well, I just want to know what you say was meant by considering whether this is a Chikwamba situation, which he then defines. Well, where does she take that forward? Where does she answer whether it is or it isn't?
Well, in my submission, reading the decision as a whole, the answer is in the concluding sentence of paragraph 33.
Right, so it is a Chikwamba situation, or isn't?
Well, it's a Chikwamba situation in the sense that the evidence as it then stood indicated that he was likely to succeed or certain to succeed with his entry clearance application. But there were other factors in the case which militated clearly in favour of coming down against him in the proportionality assessment as a whole. As my Lord put it before lunch, the question is, are there strong countervailing factors sufficient to outweigh that Chikwamba factor? And as I have submitted, that's only one amongst many. It's not a trump card. My learned friend didn't suggest it was. He said it's a factor to which the tribunals should have regard. In my submission, they have, and they've carried out a balancing exercise as they have avowedly professed to do in these paragraphs, and the punchline is, yes, he does satisfy the rules, but nonetheless there's a public interest, given the other factors, in requiring him to apply for entry clearance from abroad. But I do say it's important not to get fixated on Chikwamba to the exclusion of the other immigration factors.
Well, I understand this, but I mean, your analysis is, if it's correct, would have led the judge to say, well, this isn't Chikwamba at all, because this wasn't a refusal on the basis of process. It was a substantive refusal. So the judge isn't starting from where, as I understand it, you say she might have started, which is Chikwamba's got nothing to do with this. But instead, asking whether it is a Chikwamba situation, you say that she set the bar appropriately high by accepting that it effectively was.
Yes.
If one uses the code in that sense. And she then, you would say, cleared it because of the other considerations.
Yeah. And in my respectful submission, I do, as I say, gain some support for that by what Upper Tribunal Judge Smith says at paragraphs 53 and 54. And in particular, at 54, she says, as I pointed out, this is page 113, the judge correctly considered the Chikwamba issue as one of the factors which was relevant to the overall proportionality balance. She had recorded the appellant's submission as being the appellant would be certain to meet the rules. However, due to his immigration status, she found he could not meet the rules. The judge had found that the appellant did not meet EX1, etc., etc. And then paragraph 55, the relevance of the Chikwamba principle was therefore one of the factors which the judge considered at 33 when assessing the public interest in removal.
Right. Well, I don't expect any of everything to be completely consistent with everything else, but that evidence is a different approach at the upper tribunal level, and indeed at the first tribunal level, to when Chikwamba is and isn't engaged, doesn't it? To that which you say comes out of Hyatt.
Well,
when I understood your submission to be on the basis of Hyatt, that in these sorts of cases you'd say we're not in that territory at all. That was your opening bid.
Yes. Well, maybe it's a slightly more nuanced submission. The point is that the Chikwamba principle is clearly engaged where an application is refused on that narrow procedural ground. Go away and apply from abroad, we're not even going to consider
Well, I wonder if
the
that
other.
I wonder if that's right, or whether it's not more sensible to view what we're encoding as the Chikwamba principle, to say that it will be a factor in any case in which there's a reasonable degree of certainty that an application from abroad would succeed, and
Yes.
so sending somebody abroad to make it is futile and harmful without any corresponding benefit to the public interest. So this reliance on the approach taken by the tribunals in this case, speaking for myself, has caused me to wonder about your opening attempt to separate procedural from substantive.
Well,
sorry, yes.
No, sorry, I was talking across you. Is your submission then that if you look at the terms of Chikwamba itself, the principle that's articulated there by by Lord Brown is if an application is refused on this narrow procedural ground alone, then that in and of itself, on the facts of Chikwamba, is unlawful. In other cases, it may be relevant to the proportionality balance, but is not a trump card. Is it as simple as that?
Yes, it's as simple as that. I apologise if I've overblown the procedural point.
No,
but it is as simple as that.
Because that's where it started.
Yeah, well, I mean, one can readily see the logic of that. It's also relevant to remember in Chikwamba there was also the point about whether there was going to be one comprehensive appeal or more than one. but we're now clearly in a one-stop world where the desirability is that all factors relevant to the merits of an application for leave to appeal and subsequently any appeal from that decision are dealt with together in one appeal. And so I concur entirely with what my lady has just said, that a decision that is based purely on the procedural ground is likely, other things being equal, to be erroneous for not having engaged with other factors relevant to the balancing exercise. But when one then considers the balancing exercise, the fact that someone is certain to succeed is not a trump card. It's one amongst many factors in a multifactorial evaluation. And certainly that's the approach the tribunals take, and in one sense the narrow procedural point is a sort of atavism from history, because no decisions now are made on that narrow basis. They're made on the basis of a full proportionality assessment. Is the court content for me to move on?
Yes, certainly. Thank you.
So, dealing with Mr. Allen's case, in my respectful submission...
We're on ground 2 now. Are we on ground... This is ground 2, is it? Or we...
Yes, we're dealing with ground 2 now.
Thank you.
It is important, in my submission, to look at the course of argument before Judge Smith. Can I ask you to look in the core bundle at page 99? We touched on this earlier.
Yes.
There were two grounds, the Chikwamba ground and a reasons challenge, ground 2. And Judge Smith dealt with them in reverse order. And if one can take up the discussion at page 101, para 13, you'll see how the point was put below. So one sees it began as a reasons challenge, but then became a procedural point about the judge's approach to the evidence. It was said the judge had held against the appellant, Miss Katoon, an evidential insufficiency, which should have been raised with them as a concern if that were to be the basis of the judge's findings. And then she says the written and oral submissions therefore focused on this issue rather than the failure to provide reasons. And then she discusses the evidence and she discusses the decision of the FTT judge firstly. Then she deals with the submissions. One turns through from paragraph 14 up to paragraph 33, and one can see paragraph 17 at the top of page 103. She says, given the way in which ground 2 has been developed, it's appropriate to begin with the way in which the appellant argued his case before Judge Obi and the evidence which was presented to her. And then she sets out in some detail the evidence. And the judge's findings and her reaction to those findings. And then at para 25, top of page 105, she says, the appellant does not dispute he bears the burden of demonstrating the strength of his family life with Miss Katoon and the extent of the interference with that family life. Then she refers back to the evidence.
So there's a rather awkward double negative in the second sentence. It's not suggested that it is not for him to show that there are
yes.
Or triple negative.
I'm just wondering why we're looking at this
Well,
in such detail. This is not the decision that is our concern. I mean, obviously, we may get help from the experienced UT judge in relation to some of the legal issues, but the decision that's being attacked, which you're defending, is the decision of Judge Obi. When I can see we have to look obviously at the decision of Judge Smith in relation to Mr. Rahman, but I'm not quite sure why we're looking at it in relation to Mr. Allen.
The point I'm making is simply this, that the case at first instance was that there is evidence here to support a case of insurmountable obstacles.
Yes, I understand that you're referring to this in order to show us what the pleadings were like on the first appeal. I understand that, so that we can understand anything that's said with the knowledge of what the issues then were. But I mean, we look as if we're now going through issues to do with the merits, aren't we?
I'm going to deal with the point this way. I'm going to just come back to the specific points Mr. Malik relies on in a moment. But the point I'm making at the moment is that the case has been based on
procedural fairness.
An evidential deficiency in procedural unfairness.
Well, no, it seems to be. It was. Sorry to talk over you, but it was run before the upper tribunal on the basis that it had been unfair for the tribunal not to have sought further information from the applicant in support of his case. That was the case that was being run there, I think your submission is.
Yes, but I think I'm also making the point that Judge Obi's decision is based in large part on the fact that there was an insufficiency of evidence before her to make out the Article 8.
Well, that's what I think I said. I think I said that was my impression too at an earlier stage in the hearing, and we're not concerned with the point that the Arbitration Tribunal was being asked to consider, namely whether the Judge Obi had a duty to help the applicant get some more evidence. Your case rests, does it not, as it was in the first tier tribunal, namely that the applicant simply hadn't made out his case.
Yes.
I mean, I have a worry that I'm missing something, because otherwise that seems to me to be the beginning and the end of this point.
Well, your Lordship's right. Lord Justice Coulson, in granting permission on ground 2, said the answer to ground 2 may be that the FTT was entitled to make the findings of fact that it did. And in my respectful submission, that is the long and the short of it. The FTT were entitled to make the findings of fact that it did. But can I just deal briefly with my learned friend's
by all means.
miscellany of other points? The particular factor that he relies on as disclosing insurmountable obstacles, because that's the issue that the tribunal was concerned with, was his wife's previous care status. But in my submission, that point, with all due respect and appreciating the sensitivities involved, does not in fact do so. As Judge Smith explained, the focus of the wife's evidence before Judge Obi was on the benefit to her of her relationship with the appellant, rather than where that relationship was to be continued. That's the first point, and that's my answer to it. Secondly, there was a point about inconsistency in the decision of Judge Obi, in particular paragraphs 19 and 21. But I say, on a fair reading of the decision, there is no inconsistency. In paragraph 19, the FTT judge says, on the face of it, they are very different, etc. My learned friend took you to the passages earlier there at page 156 in the core bundle. And then at para 21, the judge simply said, on the face of it, they're very different, but the appellant's wife appears to have immersed herself into his culture. And I do say, insofar as my learned friend seeks to say that's a sort of freestanding ground of appeal, that there was insufficient evidence for that finding. In my respectful submission, one can't tease that out from his grounds to this court.
Yes.
And I do make the point, as I think was picked up by the court in looking at these passages, that the appellant's partner was of Bangladeshi origin until at least the age of 13, when she was taken into care. The third point my learned friend made was about vulnerability, and he complained that the FTT failed to have regard to its own finding of vulnerability. But in my submission, the focus of the appellant's case was in relation to EX1, the question of insurmountable obstacles, was his wife's vulnerability as a formerly looked after child. And I say that's precisely the case which the judge considered at paragraph 19. And as Judge Smith observed, the difficulty is not Miss Judge Obi's lack of reasoning, it's the lack of evidence adduced to satisfy the test. So I do say, I apologise if I dwelled on it unduly, but I do say it's the flimsiness of the evidential substrate that is crucial in analysing the merits of ground 2. And that's why in my submission, the Lord Justice Coulson was right in his preliminary observation that based on the limited evidence, the judge at first instance was entitled to make the findings that she did. Two final points, if I may. The first concerns the alleged error of law in the test applied. I respectfully adopt the point made by the court. This is semantics without a meaningful impact. But insofar as may be necessary, I rely on the respondent's notice at page 82. And again, invite the court to find that any error of law in that regard was immaterial. The final point is this: my learned friend took you to Lao, which obviously postdates the relevant decision in this case. But the point I take from Lao is the court's renewed emphasis in that decision on the stringency of the test for insurmountable obstacles. And one sees that Lao's at 254 in the authorities bundle, if one can just turn that up again.
Yes.
At the bottom of page 264, power 37, I think my learned friend took you to these passages, or certainly took you to paragraphs 35 and 36. But just below the letter H, the court there says the test cannot, in our view, reasonably be understood as subjective in that sense. To treat it as such would substantially dilute the intended stringency of the test and give an unfair and perverse advantage to a claimant who is less resolute or committed to their relationship over a partner who's ready to endure greater hardship to enable them to stay together. And in my respectful submission, such limited evidence as there was before Judge Obi was entirely subjective and clearly insufficient to meet that stringent test.
Yes.
Will your lordships, my lady, just bear with me for one moment? Unless there's anything further I can assist with, those are my submissions.
There isn't. Thank you very much indeed, Mr. Hanson.
Thank you.
Yes, Mr. Malik.
My Lord asked us to identify a decision where the Chikwamba style argument was successful. There are quite a few. I will show my lord one that is in the bundle, and that will also answer the primary submission that my learned friend has made and repeated throughout his submissions, namely that Chikwamba has nothing to do with these appeals because these appeals were not unsuccessful on the basis that it is more appropriate for the appellants to apply for entry clearance. If you look at the authorities bundle, the 19th authority is VW Uganda, page 331 of the bundle. A paradigm case, lords and milady will see the appellant arrives in the United Kingdom, the asylum claim is refused, forms a relationship with a British citizen, there are no insurmountable obstacles to relocation, the appeal fails, and the matter then comes up before this court. If you look at paragraph 43 of the judgment.
Right, we're concerned with the case of VW, not the second case.
Yes, VW, yes.
Thank you.
Paragraph 43, you'll see that the court applied Chikwamba and see the final sentence.
Can you just give me a page number, please?
Sorry, page 342.
Thank you.
So you have paragraph 43 at that page. You'll see a reference to Chikwamba. If you go to the next page, 343, the likelihood of return via entry clearance should not be ordinarily treated as a factor rendering removal proportionate. If anything, the reverse is the case. So it is a factor that counts in favor of the appellant. May I now show you how that factor was applied by this court on the facts. If you look at page 48 of the bundle, paragraph 48 of the paragraph 48 of the judgment, page 344, you'll see that Lord Justice Sedley quotes the findings made below. Just like these cases, there was a finding that there were no insurmountable obstacles to relocation. This is the middle of the quoted paragraph. So no insurmountable obstacles to relocation. And then paragraph 49, the second, Ms. Bush, who appears for the Secretary of State, said, submitted that, well, the appeal should, if there is an error of law, the appeal should be remitted. But Mr. Drabble for the appellant said that the appeal should be allowed outright, the Article 8 appeal. So he effectively asked the court to conduct the balancing exercise itself. And Lord Justice Sedley says that the decision in Chikwamba tips the scale in Mr. Drabble's direction, accepting for the present all that is said about the facts in paragraph 84, I think it's 48, see above, the likelihood, not the certainty of the appellant, that the appellant will eventually score entry clearance in order to return, far from diminishing the claim to remain, is capable, in a case such as this, of strengthening it. For that reason, the appeal was allowed outright. So the court conducted the balancing exercise and decided not to remit the appeal, allowed the appeal outright on Chikwamba basis. There's no doubt that that wasn't a case where the appeal below had failed on a procedural ground. The tribunal below made a finding that there were no insurmountable obstacles to relocation, dealt with the Article 8 claim on merits, on the facts, conducted the proportionality exercise. Lord Justice Sedley says that Chikwamba point is a point that goes in the appellant's favour. Now, I do not submit that these are two cases where the only right answer is to allow the appeal. I'm not asking the court to substitute a decision or to conduct the balancing exercise itself. Submission is that the tribunals below should have treated this as a weighty factor in the appellant's favour, and their failure to do so renders their decision wrong in law. Now, this also deals with the point that Elisabeth makes, that the Chikwamba has nothing to do with these cases. When I opened my submissions, I stated that this court has analysed Chikwamba in 30 different judgments, and there are some 50 plus decisions of the upper tribunal and the high court dealing with it. Now I can identify other decisions of this court where the appeals were allowed, and I can identify the first instance decisions too.
Could you just tell us, before I lose sight of it, in the event of success on the appeal, where should the appeals be sent? Where is it to the first tier tribunal or to the upper tribunal?
In my respective submission to the first tier tribunal.
Well, in a case, I mean, I appreciate that there may not be any logic in it, but I mean, if there was one case and it was an appeal from a fact find of the appeal from an original decision of the upper tribunal, one would normally send it back to the upper tribunal.
Yes.
Is there any particular reason in that case why one would act differently?
Yes. I've no particular preference. The reason why I said first tier tribunal is because there is a judgment. There is a recent judgment of this court that came out last week. So if the first tier tribunal dismisses the appeal on a point of law, the appellant can appeal to the upper tribunal. But if the upper tribunal makes a wrong decision, there is no appeal to this court on a point of law.
Is it this was a decision of the vice president, of a member of the court? Is that right?
Yes.
Yes.
So there's no appeal to this court on a point of law unless the second tier appeals test is met. So this court made the point that the statutory scheme provides an opportunity to an unsuccessful appellant to have a right of appeal on a point of law, and if the upper tribunal retains a matter after setting aside the first tier tribunal's decision and remakes the decision, that effectively deprives the appellant of an appeal tier. But in this particular, it may be appropriate to remit these appeals to the first tier tribunal. But I'm entirely content if my lords and my lady, if the appeal is allowed, remit this to the upper tribunal, and the upper tribunal can then make a decision.
Sorry to interrupt, Mr. Marriott. Could you tell me, please, what that case is called? The one you've just referred to.
Lady, I will. Just,
well, don't worry. I mean, maybe you could. Oh, I think your juniors maybe. He's going to tell you. All right.
Yes. Of course, the position may not be as straightforward as I've sort of summarised. But that was my recollection of reading the judgment over the weekend. But in this particular case, I said I have no particular preference. If the appeal is remitted to the upper tribunal, I'm entirely content with that. Now I've given you one example where the appeal was successful. As said, I can give you more. There is another judgment by this court where a Chikwamba style argument was successful. There are various other first instance decisions too.
So there's, as far as you're aware, there's one more Court of Appeal decision. Is that right?
There is MA Pakistan. I have copies of that judgment with me. If
you could just give me the reference, that would be really helpful.
Yes, it's 2009 EWCA Civ 953.
So these so both this case and VW Uganda are quite soon after the decision of the House of Lords in Chikwamba.
Yes.
And before all the changes that there have been since.
Yes, and okay. There are first instance decisions as well.
Well, I think we may be more interested in decisions of this court. I mean, is there a more recent decision of this court?
No.
No.
Okay.
All right.
So I mean, I've taken you to the recent judgments. But,
Okay, that's helpful. Thank you.
so what this court did in VW, I mean, I invite the court to adopt the same approach as was adopted in VW. If there is an error of law, then remit the appeal. Now, my learned friend took you, as the court will recall, to Hayat.
Yeah.
Now, may I take you to that
Just
judgment?
to short circuit this, it's a case called AEB in the Secretary of State. 18th of November 2022, EWCA Civ 1512.
Yes, that is the case.
Very
Yes.
much.
Good.
Yes.
So Hayat, in the 8th authority, page 102. And my lords and my lady will recall that my learned friend took you to paragraph 30, where there is a summary of the principles, page 111 of the bundle. This, of course, predates the Supreme Court authorities, but may I ask you to look at point D. That really is the point that is relevant here. Where Article 8 is engaged and there is no sensible reason for enforcing the policy, that policy, my learned friend says, is not being enforced here. The decision maker should determine Article 8 claim on its substantive merits, having regard to all material factors, notwithstanding the fact that the applicant has no lawful entry clearance. That's what the court decided. The issue in this appeal is whether all relevant, all material factors include attaching weight in the appellant's favor to the point that I've made.
Sorry, could you just give me the reference to Hyatt again? Which paragraph were you?
My lady, paragraph 30 of Hayat, page 111 of the bundle.
Yeah, thank you. So I'm just being
Subparagraph D.
I'm just being slow. Thank you.
Subparagraph D.
Thank you very much.
In my respectful submission, Hayat does not undermine any of the submissions that I've made, does not assist the court, because the issue before this court is whether the fact that a person will be able to return to the UK is a material factor, whether it is a factor that counts in favor of the appellant. And in my respectful submission, it does, as the Supreme Court has told us in the two authorities, and this court has repeated so in TZ Pakistan. And if you then look at F as well, subparagraph F, that Chikwamba was not intended to alter the way in which the court considers the Article 8 issue. Raskar and Huang take into account everything, but my submission really is that everything includes attaching weight in the appellant's favor to the fact that there is a likelihood of return. My learned friend took the court to Takral, the upper tribunal's decision. I do not propose to take the court to it. It's page 314. The judicial head note suggests that Chikwamba only applies where there is a refusal on procedural grounds. Surely that is inconsistent with the case law that the court has seen. It's a first instance decision, and you have the authority of the Supreme Court and this court. My learned friend then took the court to Agyako and made a point about the certainty as to the grant of entry clearance from abroad. That surely is the word that Lord Reed used. This court has used different different phrase, likelihood of return in BW Uganda. In Yunus, the upper tribunal said that it would decide the issue on balance, whether on balance the appellant will be able to return. Do not propose to take the court's time on this particular matter, because my learned friend concedes that it is certain, at least in Mr. Alam's appeal, that he will succeed if he leaves the country and apply for entry clearance. My learned friend then made submissions on Section 117B of the 2002 Act, and he accepts quite properly that Chikwamba has survived that scheme. But he makes the point that Section 117B does not, for instance, say that public interest would not require a person's removal, where that person can then come back to the United Kingdom after applying for fresh entry clearance. My respectful submission that really is the wrong way to look at the statute. And I can likewise submit that the statute does not say that the public interest will always require a person's removal, even in a case where that person is able to return to the United Kingdom after applying for entry clearance from abroad. As my lady observed when I was making submissions earlier, the statute itself is not exhaustive. There are a range of factors that the decision maker must take into account. My learned friend then took the court to Yunus. This is the presidential panel's decision. Now, can I just take you to that decision, Lords and Lady, just to respond to certain points that my learned friend has made. That's page 346 of the bundle. And my lords and my lady, my learned friend took you to paragraph 90 of the judgment. Now this replicates the judicial head note, and you have my submission about this, that there is no reference to rupiah, no consideration of the inherent flexibility. But the point that is made towards the middle of this paragraph is that there is no exception, there is no Chikwamba exception in Part 5A. Again, I say with respect, that is the wrong way to approach the matter. Paragraph 94 is a paragraph that, in my submission on analysis, undermines a submission that the learned friend has made. So paragraph 94 tells us that in cases such as this, it is for the tribunal to decide for itself, on the basis of evidence before it, whether the requirements of the rules are met. The requirements of entry clearance rules are met. And if you go to the next page, you'll see that in that case, the tribunal made its decision on balance of probabilities and said that when he will be granted entry clearance from abroad, the tribunal did not apply the test of certainty, but made a decision on balance of probabilities. It also undermines what my learned friend has said about the futuristic nature of the assessment.
So are you now saying that Yunus is correct? Because I think you were at one stage suggesting that Yunus was wrong. Or were you saying it's a curate's egg, it's partly wrong and partly right?
Yes, paragraph 94 is correct. I take no issue with that. I don't need to rely on paragraph 94 to make the point that I have made, that it is for the fact-finding tribunal to decide whether or not an applicant will succeed in the entry clearance application. One gets that from Hashim Ali and Egyako and he's at Pakistan.
I think we're, to my mind, mixing up certain things, but before dealing with that, I understood your complaint about Yunus to be limited to the fact that he didn't sufficiently emphasise flexibility per your interpretation of rupiah.
That is my
that was the extent of your complaint about Eunice, as I understood it. It was that it didn't say, an extra paragraph would have saved it from your point of view, but you say it didn't do that, and that's to be borne in mind. But this business about the balance of probabilities and certainty and so forth, that there are two different concepts at play here. The first is whether it's to be considered that an application from abroad would succeed. Now, in order to reach that conclusion, a tribunal would have to be so satisfied on a balance of probability.
Yes.
That was the conclusion. But on a balance of probability, it will succeed.
Yes.
Right. And so the tribunal is not required to say that it's certain that it will succeed. Any finding of a tribunal is going to be on a balance of probabilities. It only has to be judicially satisfied that the application will succeed.
Yes.
So that's the test that is at work here, isn't it?
Absolutely. And
it's not a test that on a balance of probabilities, or indeed on any other standard of proof, it may succeed, or it may well succeed, or it has a good chance of succeeding.
Yeah.
It will succeed.
Yes. And I mean, I thought I would just highlight this paragraph because you heard what beloved friend said. At one point, he submitted that the question isn't whether the applicant on balance will succeed at this stage. The question is what will happen in future, and that led to some discussion as to what will happen if.
Well, I think having run up that flag, he pulled it down. So
I'm grateful. So I'll leave it here. Learned friend then just closing his submissions on the point of principle, you'll recall made a series of submissions, and his first 3 points were that we were not even in Chikwamba territory. I've dealt with that. He then made submissions that were uncontroversial. I accept that public interest is of particular relevance. Chikwamba argument is not a trump card. There are no children involved here. Chikwamba was a different case. My submission simply is that it is a factor that ought to be taken as a weighty factor, as a powerful factor in the appellant's favor in assessing proportionality. I do not make any other submission. Just moving on, then finally to what my learned friend said as to the facts of the two cases. So my learned friend dealt with Rahman first, and my learned friend submitted that Mr. Rahman is certain to be refused entry clearance if he leaves the United Kingdom and applies from abroad. But my respectful submission, as I submitted in my opening submission, is that there is no finding by the tribunal as to whether or not Mr. Rahman meets the requirements for entry clearance. There's no such finding in the tribunal's decision. My learned friend took you'll recall, to paragraph 13 of the tribunal's decision, page 117 of the bundle. And because of what is said at paragraph 13, my learned friend said that, well, the appellant is bound to fail in the entry clearance application. But that surely isn't what the tribunal was saying in that paragraph. Now you'll see that at paragraph 13, the judge referred repeatedly to ELTRP. Now that is eligibility leave to remain as a partner. The tribunal was considering requirements for leave to remain from within the United Kingdom as a partner. Entry clearance requirements are dealt with in an entirely different part of the rules. That is referred to as ECP. You have the rules in the bundle, but this isn't surely an assessment as to the entry clearance requirements. These are This is an assessment as to the eligibility requirements for leave to remain under the immigration rules. That is why one sees repeated references to EX1. That only applies
Is there a language requirement under ECP?
There is a language requirement, but it has a number of exceptions, as is the financial requirements. And I'm not asking this court to look at those requirements and to decide for itself as to whether or not those requirements are met, because to do so would be inviting the court to sit as a first-year tribunal.
But what is the nature of the challenge in that case? Because it's effectively for Mr. Rahman to show that he's certain to succeed. And so how is there an error of law?
My submission is that the judge was obliged to consider and determine whether Mr. Rahman will succeed in the entry clearance application. The judge did not do so. That is an error of law. Justifies remittal so that the tribunal can look at this question, consider submissions from both sides, look at the rules about the entry clearance, and then make a decision one way or another.
Surely there's some procedure whereby if it's considered that there is a material error of this kind, you ask the judge to make a finding about it. You can't come here and say the judge didn't deal with this, so therefore you have to do it all again. If you haven't asked the judge to make good something that you say is critical.
Yeah. The answer, Lord, in my respective submission is that paragraph 85. That paragraph in my submission tells us why the judge did not conduct that exercise. The judge did not conduct that exercise because the judge took the view that Chikwamba has nothing to do with this case, and the appellant simply cannot succeed on Chikwamba basis because there are no insurmountable obstacles to relocation. And because of what is said at 57. So in Asylum, of course, there is a positive finding that all the requirements of the rules are met. Miller and Friend concedes that is the case. But this is an instance where there isn't a finding by the tribunal as to whether or not the requirements of the rules are met, and that is how I put my challenge to the tribunal's decision. Now, in Mr. Alam's case, Miller and Friend, as my lords will recall, concedes that the requirements for entry clearance are met. He invites the court to read the tribunal's decision as if the judge took Chikwamba point in the appellant's favor and then nevertheless dismissed the appeal. But my Lord Justice Peter Jackson was absolutely right with respect when my Lord observed that the judge identified the question at paragraph 32 and then underlined the word certain, that the judge had to consider whether or not the appellant is certain to be granted entry clearance, but did not answer that question. If you look at paragraph 33, the judge expressly identifies matters that were in the appellant's favor. The judge says, in the appellant's favor, and then he outlines 3 particular matters. What he has not outlined there is the Chikwamba point. And the reason, in my respective submission, is that the judge did not consider that was a point that was in the appellant's favor in the proportionality balance. You'll see that paragraph 33 is in 2 parts. So in the first part, the judge identifies 3 points that were in the appellant's favor. And then in the second part, this is the 4th last line at page 159, against his interest, and he then considers the public interest considerations. But in my respective submission, misses out the obvious point. Now on ground 2, Well, Malone Trent says that this isn't a case where there were insurmountable obstacles to relocation. I'm not seeking to persuade this court to find that there are insurmountable obstacles to relocation. That isn't a question for this court. This court is not sitting as the first year tribunal. The question for this court is whether the judge below erred on a point of law in concluding that there were no insurmountable obstacles. I made 5 specific points in my submission explaining why the reasons given by the judge were flawed. If those points are well founded, the judge's finding of insurmountable obstacle cannot sustain. The appeal should be allowed. The matter should go back to the first year tribunal or the upper tribunal, where they can decide on the evidence whether the insurmountable obstacle test is met. And I do not, I do submit actually that it isn't appropriate for this court to sit as a first instance tribunal and to look at the evidence and submissions and then decide for itself as to whether the test is met. This isn't a case where the evidence that is recorded in the decision was incapable of meeting the test. We have wife has a difficult upbringing, difficult childhood, is born here.
Well, if the submission is that we shouldn't be making original decisions ourselves, you're pushing to an open door.
I'm very grateful, very grateful. So Malone Trent, in my respectful submission, offered no proper defense to the 5 points that I made.
Just to explain why I say that, I mean, there was a certain amount of correspondence previously about the bundles, and we were told in the end that we needn't refer to the substantial supplemental bundle, which would contain all the original material that would be necessary to consider making a decision of any sort ourselves. And so, certainly speaking for myself, that has remained closed. So for that reason alone, we're not equipped.
I'm very grateful. So perhaps just to conclude my submission. So I have taken you to Lal. Malone Trent also took you to Lal. That too was a case where this court essentially said that, well, there was a flaw in the approach adopted by the judge below, and allowed the appeal on that basis. So if there is an error of law in the first year tribunal's decision, it wouldn't have been open to the upper tribunal to uphold that decision. Unless I've misunderstood Malone Trent's position, no pleadings point is being taken. If the submissions that I've made about the first year tribunal's decision are well founded, I invite the court to allow the appeal on that point too. So unless I can assist the court any further, these are my submissions in reply.
Thank you again, Mr. Malik. Very well. We express our thanks to everybody who has participated in the preparation and the arguing of these appeals. We'll take time to consider our decisions and our judgments, and let you have them in the normal way for editorial corrections and the agreement, please, of consequential draft orders. There'll be no need for the parties to attend for what will be an electronic hand-down in accordance with the normal procedures now operating in this court. Thank you very much indeed.